Hello and welcome, everyone. Thank you very much for joining us today for this IISD webinar on international investment law, examining the issue of compensation and in particular, the valuation technique known as discounted cash flow analysis. My name is Natalie Bernasconi and I am the Executive Director of IISD Europe and also head IISD's Economic Law and Policy Program. This webinar is part of a series of discussions that IISD has been hosting since 2019 to turn the spotlight onto an area of international investment law that has received relatively little attention in the ongoing investment treaty reform discussions to date: the issue of compensation or damages. To some extent, this is surprising because it is the issue of compensation and the legal principles and valuation techniques that arbitral tribunals apply that will ultimately determine how much a state must pay to investors when the breach of a treaty has been found. In that sense, it is an issue that touches at the heart of concerns around state sovereignty and the financial impacts of investment treaties on limited state resources, especially for developing countries. Yet, unlike other issues such as substantive investor protections or procedural aspects of investor-state arbitration, there are very few reform proposals on the table to address the issue of inflating award sizes and inconsistent approaches to calculating damages. But to generate ideas for how things could be different, we need to understand how they are now. This is why we are so thrilled to have an esteemed group of experts to unpack and analyze the use of discounted cash flow analysis as a technique for valuing investments for the purpose of awarding compensation. Discounted cash flow analysis, or DCF, is an accounting technique that aims to determine the value of an investment by estimating its future cash flows and applying a discount rate to determine the net present value of those cash flows. Now, don't worry if this sounds confusing, because our panel will explain all you need to know. Let me just quote an eminent international investment lawyer, George Cahill III, and what he said about DCF, or discounted cash flow. If you thought the concept of fair and equitable treatment is susceptible to abuse, you haven't seen anything until you've seen what an imaginative claimant, supported by its expert, can come up with in quantum using DCF. Quote finished. DCF is arguably one of the driving forces behind the recent rise in mega awards, which is why it is critical to understand. Today, our panel will discuss why this technique is increasingly used in investment arbitration. They will explain some of the considerations and challenges surrounding its use, and they will highlight the problems it can pose for states. I now have the pleasure to turn over to Dr. Susie Nikiema. Dr. Nikiema is a senior international law advisor who also leads IISD's investment program. She will be moderating today's panel discussion. Susie will introduce our expert panel and the structure of the webinar and be with you throughout the webinar. Thank you very much. And Susie, the screen, the mic is yours.
Thank you very much, Natalie, for this introduction that set the scene and provides an excellent background for the discussion today. and good morning and good evening, everyone. I'm very happy to introduce to you today 4 estimate experts who will be discussing the key issues raised by the use of the DCF valuation technique. Each speaker has a wealth of experience and in-depth understanding of DCF, but each from a different perspective in private practice, government, and academia, which will greatly enrich our discussions. To open today's discussion, we are honored to hear from Mr. Mohamed Usman Piracha, who is a senior legal consultant specializing in international dispute with the Attorney General of Pakistan. Usman will set the scene for the panel discussion by sharing valuable reflection and insights from a state perspective, and he will be speaking in his personal capacity. We will then open our panel discussion, and let me introduce to you our 3 panelists. First, Mrs. Christina Barry is an attorney in public international law and investor state arbitration with the firm of Foley Hoag. Christina is often responsible for damages arguments in high-stakes investment disputes, and she recently edited a book on the law of damages and valuation in international investment arbitration. We have also with us today Dr. Tony Marzal. He is a lecturer in private law at the University of Glasgow, and Tony specializes in conflict of laws, AU law, and international investment law, and he's currently conducting research on the assessment of damages in international investment disputes. Last but not least, Professor Lou Wells is the Herbert F. Johnson Professor of International Management at the Harvard Business School. Professor Wells has served as consultant to governments of a number of developing countries in the context of investor-state dispute. As you can see, we have the best panel to discuss this topic today. And on behalf of IISD, we are extremely excited to have all 4 of you joining us today to discuss this important topic. The structure of our webinar will be as follows. After Usman's opening remarks, we'll have a moderated panel discussion for about 45 minutes with Christina, Lou, and Tony. And I will then ask Usman for his reflection and reaction to the panel discussion, which will allow us to have plenty of time for questions and Q&A session with the participant today. Please feel free to post your question in the Q&A and chat boxes at any time during the discussion, and we'll aim to address as many of them as we can. I would like to ask Usman to share his reflection, about experience of his country regarding the DCF method. As we know, Pakistan has experience in that regard. The floor is yours to Usman.
Thank you so much. And it is an absolute pleasure and honor to be here amongst the wonderful panel we have today or tonight, depending on where you are. And to carry from what Natalie explained, the problem with discount cash flow is not that there is something structurally wrong with the approach. It is how it is used and in the manner that it is used that creates complexity. Now, let me start by first explaining what cash flows are, because we have a diverse audience and let's not presume that everyone is on the same page. Think of cash flow as a monetary transaction in or out of a company. If we take all cash flows, all of these monetary transactions over the life of a company, and we bring them to the present value to assess whether the company would have made profit or loss over its life, then we have discounted the cash flows and have managed to acquire a certain value. That could be a profit or a loss. Now, when we do these evaluations, the challenge is that sometimes risk is not adjusted in the manner that it should be. So for example, what future risks there may be for a company that could affect its cash flows? And how do we cater for those risks? Now, historically, there has been disagreement amongst tribunals about how to account for the range of risks facing an investment when using the DCF method. And it has come to knowledge that the DCF method appears to have worked better and in a more reliable manner when we are evaluating investments with shorter expected lifespans. And that's very important for the case that I will be talking about in greater detail. But let's move to what modern DCF is about. The issue with modern DCF is that where DCF alone would have used a risk-adjusted predicted cash flow and would have used a measure to calculate that risk in the most appropriate way, the modern DCF, which was used in the Tatian case, actually does it a bit differently with a huge impact. So basically their position is, the tribunal's position in the Tatian case with regards to modern DCF was that to consider the implications of uncertainty about predicted future cash flows, the risks associated had been fully accounted for in the cash flow predictions. And therefore, there was no need for any further measure or gauging what risks there may have been. So in effect, the notion is that the risks are inherently considered when those cash flows are discounted to present day value. It may seem like a small or perhaps even feasible approach, but the problem comes when we talk about its implementation. The Tatian case, early 1990s, a large mining conglomerate wants to invest in one of the remote regions of Pakistan to explore the minerals of copper and gold. A dispute arises. Pakistan wins that dispute in its local courts, but loses that dispute in the World Bank Tribunal, the IISD Tribunal. And it's not just an ordinary value of damages. The damages are to the tune of $5.9 billion. And let's put that into perspective. The company in question had invested about 167 million in 2006. So for a mining project that never saw the light of day, that did not mine a single ounce of gold or copper, did not have a single profitable transaction, actual transaction to show, was awarded 5.9 billion US dollars in damages. The tribunal could have used a different approach. They used the modern DCF approach. Let's suppose if they would have used the average of forecasts made by various commercial and academic institutions to predict the future trajectory of the price of copper, gold, and oil, because these were the three essentials that were needed to understand what profits this company, TCC, if I may use the abbreviation, the Tatian Copper Company, would have made. And if we would have used the average of forecasts by various commercial and academic institutions, do you know what profit they would have made? Well, they would not have made a profit. It would have been a loss. So in one measure, you have a loss. And in the modern DCF, Pakistan is liable to pay about $6 billion. Perhaps the question could arise, well, maybe modern DCF is the right approach. Maybe modern DCF has to be used. There's nothing wrong with it. But I have a list of cases that I will just sift through quickly because I am cognizant of the time, which would dispute that argument. For example, the ADM in Mexico case, where it was held that the respondent's position regarding the profits anticipated were probable or reasonably anticipated were not sufficient enough to actually calculate the damages in question. In Vividini and Argentina, it was held that compensation is generally awarded only where future profitability can be established. And mind you, this mining company had not had a single profitable transaction on the ground. Bear Creek case, where the modern DCF was put under a microscope, and it was held that there was no room for a modern DCF evaluation, even though Bear Creek was perhaps in a much advanced state of actually having something on the ground than TCC ever did. And then we could go on, but the point being that here we have an award that is twice Pakistan's entire public spending on healthcare of 200 million people, in a country where about 7% of children die before their 5th birthday, is equivalent to the IMF loan that we were able to secure around the same time that this judgment came around, 6 billion, has not only eroded the trust in international arbitrations, but has decimated the countries involved. And what do we have to show for that? A large award that remains hanging over Pakistan's economy? So I would now like to turn to the panelists so that we could have a further discussion on that note. Thank you.
Thank you very much, Usman, for sharing your views on DCF from your country perspective. And it's really important to hear your views, putting this large award into a specific perspective from human perspective, because after all, at the end of the day, it's life of the population in the country that matter. I think you have provided a lot of food for thought, and I'm sure our panelists will pick up on some of the things you have shared. I keep in mind that you said you are not, as a principle, against using DCF as a valuation method, but it's important to assess and decide when this method, this technique is appropriate, and particularly can be challenging for projects that were at a very early stage of development and design. So thank you so much. So now it's time for me to turn to our panelists, and I would like to address my first question to Tony. Actually, when Usman started his presentation, he provided a definition of DCF, and Natalie also touched upon about that. But we know it's a very complicated technical notion, and it can be confusing. So what I would like you to do first is to explain us in plain English, the simplest way, what exactly is DCF, and how does it compare to other valuation techniques that are used in investment arbitration? Please, Tony, you have the floor.
Thank you, Susie. Yes, what is DCF? So DCF at the most fundamental level, so it's a method evaluation. So it tells us how we're going to measure the value of something. And so the fundamental, sort of the starting point for DCF is the idea that the value of something, the value of an asset, stems from its ability to generate income in the future, right? So that's why we say that DCF is a forward-looking valuation method. It looks to the future. So, for instance, if we take the example of a mine, what is the value of a mine? One could potentially look to the amounts that were historically invested in that mine. That's something that Usman was referring to. Or we could think about turn to the price that was paid by other investors to acquire similar mines to give us an idea of what the value of that mine is. But from a DCF perspective, none of that is truly relevant. What counts is how profitable is this mine going to be in the future? And that's what's going to tell us what the value of the mine is. So that's what's most fundamental. The DCF is a forward-looking and that it requires some speculation about the future and what the future is going to bring. So I think it's a relatively simple idea. It's relatively intuitive, but in practice is of course very, very complex. And it can be basically broken down into two main steps. So the first would be projecting these cash flows that the asset is expected to generate, right? So with a mine, this may involve questions about the extent of the mineral deposits that the mine will have access to, what will be the price at which those minerals will be sold again in the future, again as Usman was referring to, what will be the costs involved in extracting, etc., etc. So that would be the first step, those projections of future cash flows. But then once we have that, we are going to be subjecting, that's the sort of the discount part of the discounted cash flows method. We're going to subject those income streams to discount rates. And this is to bring to give us the present value of that expectation of future income. So this discount rate is essentially going to be meant to account for two things. Well, essentially, what is referred to as the time value of money, the idea that receiving $1 today is worth more than receiving it tomorrow. But the most important is the second, which is to reflect the risk of those projections not materializing. So, the riskier the investment, then the higher the discount rate will be, and therefore the lower its value. So, for instance, whether markets for the mineral in question are very volatile, or where the country risk, the risk of this perceived in investing in a certain country is very high, then the higher the discount rate, and therefore the lower the value. And vice versa, where the markets are perceived to be very stable and the country is perceived to be very safe, i.e. that there's no real danger of regulatory upheaval, these kinds of things, then the discount rate will be very low and the value will be relatively higher, right? So in sum, you have, the idea is that it's a forward-looking method. It's based on calculations about the future. And secondly, these calculations are quite complex and they are broken down into an estimate of what that future income is going to be, and secondly, the appropriate discount rate. Both of which things can have a huge impact on the final sum, as illustrated very well by Usman. And of course, both of which will be subject to, will be extremely contentious in the practice of arbitration.
Thank you very much for this very clear and illuminating definition. I think it's now very clear for everyone on this webinar, even those that are not familiar at all with this topic. But what I'm hearing from you is that this technique involves so much parameter to be taken into account, and this may be lead to, let's say, a lot of speculation. I will stop here for that and now turn to Christina for my next question. Christina, could you explain to us how the quantum phase of an investment arbitration works? Because not all of the participants are familiar about this kind of procedures, and why this choice of valuation technique is so important and often so contested.
Thank you, Susie. First off, I'd like to thank the organizers for inviting me to participate on this panel. And I'd also like to sincerely congratulate them for having the foresight not to just organize this particular panel on the DCF, but for actually creating a series of events on the topic of compensation more generally. I understand many of those participating on the call in the audience are government representatives, and therefore know that the focus of a state's defense is typically, and with good reason, on jurisdiction and the merits. But as a practitioner that focuses mainly in state defense, I can't stress enough the importance of also mounting an equally strong defense on damages. And that's because exposing the weaknesses in an investor's damages case can lead a tribunal to actually award zero damages, even if there is a finding of jurisdiction and liability for reasons of lack of causation, for example, or at least significantly reduce the value or the amount of damages actually awarded. But getting back to the topic at hand, I think you've asked two questions there. So I'm going to start with the first, which is how the quantum phase of an investment arbitration works in practice. And based on my own experience, quantum is handled in at least three different ways. And the first is, in my experience, the most common, and that's where jurisdiction, the merits, and quantum are handled all together in both the written pleadings as well as in the hearing itself. In other cases, jurisdiction may be bifurcated from the merits and from damages. So the parties will only proceed to deal with liability and damages if the tribunal upholds its jurisdiction. A third, and in my experience, less common approach is taken by some tribunals to have the parties make additional submissions after the end of the full hearing. And this step isn't typically contemplated at the outset. Rather, it arises in the course of deliberations of the arbitrators, I suspect, where the tribunal subsequently wishes to gather more information about the financial nature of the harm. In the interest of time, I think I'll move on to the second part of your question, but we can certainly explore the merits of each of these approaches in the Q&A if there's interest. So the second part of your question is why valuation techniques matter and are so hotly contested. Mm-hmm. And the reason why it matters is that certain valuation techniques naturally result in higher values. For example, Tony was just speaking about forward-looking valuation methods, and these are methods that really focus on an asset's profit-making potential. So those typically result in higher values. Income-based approaches, such as the DCF, are a good example of this. Others are market-based approaches that look at comparables, whether it be comparable transactions or comparable companies. I should note, however, that this is not always the case. For example, I've been involved in at least one case where the DCF produced the lowest valuation, quite to our surprise. Turning to the alternative approaches, those are the backward-looking methods. These are methods like book value, liquidation value, sunk cost, and they focus primarily on the past investment-related expenditures. And you also asked why this matters, why is it important? And the importance is that the higher valuation produced by these methodologies provides a sort of anchoring effect. Sarah and Jonathan produced a paper last year that covers this very well, and I encourage all of you listening on this call to read that paper. It's very good. And the concept here is that tribunals will use this initial higher value as a starting point, and then from there make downward adjustments based on its acceptance of the state's criticisms of the implementation of that particular methodology. And as a result, you often find states challenging in the first place the methodology, in primarily the DCF method, before it even goes into criticizing the inputs that are used in the actual calculation itself. In the interest of time, I'll leave it there, but I'm happy to explore some of these ideas again in the Q&A.
Thank you so much. I'm sure your explanation will raise a lot of reaction from the participants in terms of alternative, in terms of why it is a hot topic, as you rightly pointed out, and with various perspectives, depending from government perspective, from the investor perspective, and from the tribunal perspective. So thank you so much. And having said that, I would like to turn to Lou now for my third question. And we have noted that the use of DCF as a technique in respect of investment without a track record of profitability, for this very earlier phase project has increased relatively recently. If you agree with us, could you explain a little more about how it is used to be perceived for this type of early stage project and how that has changed in the last couple of years in the investment arbitration system?
Thank you for having me here. It's a pleasure. It seems to me like 4 questions have been raised so far. One is, should one use DCF at all? That question has been raised specifically for early stage projects where you have no track record. And for some time period, the assumption was that DCF was not appropriate for evaluating projects where you have no track record. You have no record of production, you have no record of what investment costs would be to bring it into production. World Bank guidelines indicated that one should not use DCF for that kind of project. Increasingly, DCF has been used for that kind of project by tribunals in spite of the sort of academic objection and the World Bank objection. And I think it's because, or you ask why, I think it's because of the difficulty of finding alternative ways of valuing projects. Comparables is put forward as a method. Find other projects, transactions in other similar projects, and use that as a basis, which is what one does domestically with real estate commonly. But it's really difficult in, say, a mining project that hasn't begun production to find comparable transactions. And essentially every time one tries to introduce that method, the other side undermines the comparability of the so-called comparables. And at the same time, tribunals have tended not to be impressed with the amount actually invested as a basis for awarding damages. And I think partly because the assumption is in some cases that the discoveries in the mine are worth more than indicated just by what the investor has put in. And often they see the actions of government as being opportunistic. The investor made a rich find. Now the government wants to take it over in one way or another. And that's not fair to the investor, according to tribunals. Now, it's usually not that explicit, but that seems to underlie the turning to discounted cash flow. So one of the questions is whether discounted cash flow should be used at all, especially for early stage projects. Personally, I would like to see it banned. I don't know the mechanism to ban it for early stage, but I don't think it's appropriate. There's too much guesswork in the projections. And the second question, which I think is terribly important, if one's going to use discounted cash flow, what's the discount rate? And that's been so important in projects, and there's not a good theoretical answer. It's really an empirical question. What do investors use as discount rates if you're trying to find the market value? That's a closely held secret by most corporations. So determining a discount rate that's acceptable to a tribunal is not an easy task. And one finds very different country discount rates applied by different tribunals in the same country at the same time. And that yields very different values. The third is whether one should use the so-called modern DCF versus the traditional DCF. There's nothing modern about the so-called modern. It was what I was taught in the MBA program in the early 60s. Try to account in each cash flow the risk associated with that cash flow. Now it turned out, that great in theory. In practice, it was just too difficult. And in fact, companies don't do it. Try to explain to a board of directors what you did when you present a net present value where you've accounted for risk in each element of the cash flow. Give up, it's not gonna work. But it's now been introduced in a number of arbitrations by investors. And why has this happened? Because there's a very neat and expensive computer program that one can buy. It costs a couple of $1,000s. And if you use it, you can hide virtually everything. It's very difficult to determine what adjustments were made to each of the cash flows when the tribunal is presented with this. And I think what this does is put a huge burden on the attorneys on the other side to question the expert. And that means the attorneys really have to understand what is happening in this computer program. That's difficult. And I've not seen very good cross-examination so far. One of the elements in that cross-examination should be, why did your modern DCF yield a result so different from a traditional DCF? In theory, they ought to yield essentially the same answer. If I can refer to the Tetion case, the modern DCF introduced by the investor came up with a valuation of something like $8 billion initially. The traditional DCF that the investor actually had done before the arbitration yielded a value of 0 for the project in any reasonable discount rate. Now, that's a line of questioning that ought to undermine the investor's proposal, but it takes very sophisticated attorneys to do that. And I guess there's another question raised, which I'm not going to try to address, but I think it's an important question, and that is, should arbitrators consider the impact of the quantum calculation on the host country? In the case of Pakistan with an award of $6 billion, or the Nigerian infamous Nigerian gas processing plant with a similar award, where their investor had put up only $1 billion and getting an award of $6 billion. What's the impact on Nigeria or the impact on Pakistan? It doesn't come up in arbitrations in my experience, and I think one might raise it.
Thank you so much for this rich and detailed response on the question. It's really illuminating. And I was quite surprised to hear that different tribunals can use different discount rate for the same country, which is quite, concerning. So I think you raise a lot of issues that are, as other panelists that are discussing now on the chat. I can see that we already have a lot of questions. And since we want to make sure we have time for a Q&A discussion, I will now turn to the third round of questions to the panelists. And hopefully we will have at least 20 minutes full time for discussion with the participant. I kindly ask the participant, if possible, when they ask their question, they can dedicate it to one specific panelist. Up to you, but this can be also helpful to allocate the questions. So now for the final round of questions, I would like to start with Christina this time. Lou just highlighted the importance of government attorney general to really understand these techniques, what is at stake, and be very well prepared. You are advising government in this kind of arbitration. So from your perspective, what are some of the practical considerations and challenges for respondent states in the arbitral quantum phase when DCF is used? Maybe you have some high level recommendation or tips to share with the participant to this webinar. And what are some, let's say, if you have, tactical advantages for investor when this DCF technique is used? Christina? A lot of questions, sorry, at the same time.
So for developing states, and I think states that are generally new to investment arbitration, the quantum phase can certainly present its own unique challenges. First, of course, there's the absolute shock value of the amount of compensation sought by the investor, which may be in the hundreds of millions of dollars. But compounding this is just the sheer complexity of the damages analysis itself. So while common, obviously, in the world of finance, the DCF calculation itself is not familiar to most attorneys. So needless to say, it's difficult to challenge something you don't understand. Likewise, the investor's expert report will be supported with its own exhibits and worksheets, in addition to the large amount of materials that are submitted with the memorial itself. So there's an overwhelming amount of material involved in these cases. It's therefore very important to devise a damages strategy from the outset. So once a case has been filed, the state and its counsel should begin to identify potential quantum experts with the requisite background and experience in those types of cases. This, of course, drives up the costs for the state, but engaging a good expert is really a critical component of the state's defense. That's because an expert provides not only just a strong rebuttal to the investor's expert report, but it can actually help you with other arguments, other aspects of the case, for example, relating to the merits in terms of determining whether there has been a substantial deprivation, or even challenging the causal connection between the breach and the harm in a quantitative sense. And if successful, the state itself may be able to claim the costs of the expert's fees. But another challenge, I think, for states is with respect to gathering evidence. And this is necessary in order to challenge the assumptions being made in the DCF calculation with respect to projected revenues and costs. But most of the time, this evidence relevant to the damages analysis is in the possession or custody or control of the investor. This is not, of course, always the case. In fact, there are some cases in which investors have argued that, the records aren't available to them because of having to flee the host state very quickly. Though for most well-organized companies, it could be argued that, certain types of data could be expected to be stored electronically or kept in duplicates in the investor's home state. But in any event, when records are in the possession of the investor, it's then in a position in which it can put forward sort of the best financial data to support a higher valuation. And while the state will have an opportunity to request data and document production, this normally happens after the state has already filed its counter memorial and its own expert report. So it's really only possible to use any evidence that's obtained through document production in the second written phase. There's also no guarantee that the tribunal will ultimately grant these requests if they are opposed by the investor due to numerous, grounds that are available under the IBA rules on the taking of evidence. And certainly it can't be assumed that the investor will necessarily be able to locate these documents that have been requested and granted by the tribunal. As a result, the state and its expert will have to look to other sources for information, and sometimes that involves a little bit of creativity. For example, speaking to former employees or business partners, if it's a public company, looking at the security filings and press statements, and also just looking through press articles for information. So I would certainly agree that the use of the DCF method can present certain unique challenges for states. Thank you.
Thank you very much for sharing your practical experience. I think you provide a lot of useful information from our attendees today. I'm still looking on the time, and it's crazy how when discussion is interesting, you don't realize the time is flying. But now I would like to turn to Lou to come back again on what he has said about the complexity of his techniques. And just to understand from your perspective, what are some of the issues raised by for tribunals by the complexity of DCF models? I mean, imagining a tribunal with full of lawyers, eminent lawyers, having to navigate with its complexities and economic and financial complexities. What is, I mean, in terms of reality for them to be able to navigate? What is your experience here? I know you already shared a bit about it and modern DCF, but can you just come back very quickly, let's say very quickly on that?
Sure, I think the respondent, the host country, has two mechanisms to undermine the investor's claim when it's absurd, which it often is, and increasingly is. And that's their own expert report. And that's often really too complex for a tribunal. It tries to accomplish two things: undermine the investor's claim and propose an alternative valuation for the quantum. Sure, it's the job of the expert in testimony to try to explain this in terms that a tribunal can understand. But in my experience, the expert doesn't always get a great opportunity for this. Rather than having a substantial amount of time for a presentation, goes immediately to cross-examination, which makes it tough for the expert to present a coherent and simplified argument for a tribunal. It happens both ways. Sometimes there's opportunity to make a presentation, and sometimes it's not. And the other opportunity is the attorneys for the host country. And I think it is really important that they thoroughly understand the quantum analysis on both sides, because their task is to cross-examine the expert for the investor. And they can't do that unless they completely understand the method used and where the flaws are in the approach. And I think that means they have to spend a lot of time, and that means money, with their own expert to understand what the own expert's saying about the other expert, and to bring that out in cross-examination. And I've seen that done well, and I've seen that done poorly.
Thank you very much. That's really important to keep in mind. I think I can take, again, 5 or 10 minutes to go through the last question I had for the panelists. And I'm sorry to ask you, but maybe if you can shorten a bit your response. It's interesting, but we would like to make sure we have time to respond to a lot of questions I can see now on the chat. And now I would like to turn to Tony with a combined question. First being that we know the choice of valuation method was seen as an economic question rather than a legal question. And maybe you can explain us very briefly the reason behind the growing dominance in DCF technique in that context. But more importantly, we heard a lot of explanation regarding the importance to have alternatives and the difficulty to find alternatives, actually. From your perspective, do you have some alternative that you think can be proposed to using DCF technique? Tony, please.
Yes, I have the solution here. I will, let me explain. Now, why is it now perceived to be why is it important, this question of whether it's perceived to be an economic or a legal question? I do think that it's very important, and I think that what lies behind the rise in DCF is precisely this shift, where before it was seen to be this question of valuation method was seen as a legal problem. Now it's seen as a more economic one. It's important because it affects how a tribunal will decide whether DCF is the method to follow, right? So imagine you have an investor and he has suffered some kind of breach of the state's obligation. And as a result of that breach, that investor no longer has an expectation of future income that it used to have, right? Or that expectation has been reduced. So how do you calculate compensation then? Now, if you approach it from a legal angle, it's going to be a matter of deciding what was the entitlement of that investor. Does that, legally speaking, does that investor have the right to those future profits, right? This is very much a legal question because it's a rights question, right? So if you approach it from an economic or a financial angle, the key question is different. It's how would a real life investor have valued this expectation of future income, right? And it's just a pure question of fact. If it seems sufficiently probable from an evidentiary point of view that this investment would have been profitable in the future, now that might be enough to justify the DCF method, right? So I think that's where the shift has happened and has led to a big expansion in the sort of the use of the DCF. And I think that that's where I believe that the main alternative to the sort of the current approach is to take seriously the idea that valuation questions are legal questions. So I think if tribunals take this idea seriously, I think they would do two things. So the first would be to consider at the start whether the investor has actually any protected right to future profits. So as I said earlier, this may probably not be the case if the harm suffered by the investor is the loss of an opportunity of obtaining some kind of lucrative contract, some kind of lucrative mining license, but which it hasn't yet obtained, right? If that's the case, then a cost-based valuation method seems completely appropriate, right? Now, if the investor is entitled to compensation for the loss of future profits, now I think that then tribunals should consider what is the extent of that right. So I think, let's say that the investor is rightfully operating a mine, it's his or hers or its, and that right has been taken away, right? In that case, I think it's fair to say they are entitled to some protection for the loss of future profits, but how much? Now, the tendency here is again to approach it as a purely factual question. Well, what is the most probable income stream that this mine would have generated in its expected life, right? Now, we forget here that this is not just a purely factual question. We forget that the states also have a legitimate prerogative to determine profitability, for instance, by raising taxes, by decreasing taxes, by altering the regulatory environment in legitimate ways, right? So since this is the case, I don't think we can say that the investor has the right to obtain compensation for the level of profits that may have been projected as most probable at any point in time. It's not just a factual question. What we need to do, what tribunals should do, is approach this as a compromise between, on the one hand, the need to protect the right of investors to future profits, where this right actually exists, and the right of states to intervene in the economy, to affect profitability through taxation, etc. Right? So if we accept that there is the need to approach this as a legal question or even a political question of obtaining a compromise between conflicting interests, I think it becomes possible to accept that profitability should, in many cases, be capped, or as a general matter, that compensation for the loss of future profits should not go beyond a reasonable rate of return. I think that's the limit of the entitlement of investors. And I hope the tribunals will take this seriously.
Thank you very much for this clarification and this concrete proposal. I'm pretty sure participants can discuss about his later events as well as other panelists. I think the question of legal perspective versus economic is so important, because if we take it from legal perspective, it means that government, when they are signing investment treaties or dealing with negotiating contract, they can put the principle, they can put what they want as legal principle to govern the compensation. And so this is really something important to keep in mind. I have a few more questions for the panelists, but given the time, and because I think during the past discussion, you already touched some of them. I know that Christina shared with us an example of a very, let's say, surprising way of using DCF technique when it leads to have a lower amount. I wanted you to provide more insight on that, but maybe you can share it on the chat directly with the participant. And also, we already touched base on the importance of the choice of a discount rate in the DCF method. And we understood from you, Tony, for example, that it's so important depending on how you fix this rate. And sometimes we have different rates for the same country, as Lou shared with us. So I suggest that for this question, if you want to elaborate more, you can do it directly on the chat. If you allow me to do that, sorry about that, the time is flying. And now I would like to give a chance maybe for 30 seconds. I'm sorry about that. Use Usman, if you want to reflect on something that was shared previously by the panelists before we open the floor for the Q&A session. Usman,
Thank you so much, Susie. I'll make this very short. I agree absolutely with Louis and his position that DCF should not be used for projects such as that was Tatian, where profits were being extrapolated over 50 years. It's fine for much smaller projects. I'll harken back to a view of Christina with regards to using experts. The challenge for countries like Pakistan is the associated legal fees. The legal fees rocket so high at the initial rounds that it's just hard to manage that argument part associated with when modern DCF walks in the room. I completely agree with Tony and his view about governments factoring in the possibility of changes in legislation and licenses so that the companies, if their profit is quote unquote harmed or affected, that it is managed properly, that it is not considered as a authoritarian position taken by a government against a company. I have more, but I am aware of the shortage of time. So the floor is back to you.
Thank you very much, Usman, for this specific sharing this practical impact on government perspective. I would like now to open the Q&A session. We received a lot of questions on the chat. And I would like to invite my colleague, Joe, to maybe share what are the main questions we have received and comments from the participants, and give a chance to the panelists and to Usman to reflect on some of them, maybe picking what they think are the most they would like to intervene on. Joe, are you with us?
Thank you, Susie, and thank you all the panelists for your insightful and very exciting discussion on this very important topic. Now we do have loads and loads of questions still coming in the Q&A and the chat. Given the time, I understand we're a bit short on time. I'll try to group them together. So instead of asking them one by one, I'll try to group the question in the way that I understand them, and ask the panelists all together. So please bear with me, and please excuse me if I missed any of the important questions, and please remind me in the chat box. So first of all, we have I think, a very straightforward question, a technical question, asking in terms of the discount cash flow calculations for the future. When we're talking about future profits, will tribunal consider that some sort of subsidies or benefits that would have been granted to the investors should the investment continue? Like, for example, in the special economic zones, the government usually give tax havens or tax holidays. So for 20 or 30 years, would that 20 or 30 years of tax holiday be calculated in the discounted cash flow? That's a very straightforward question. And I see lots of other questions fall into a bigger question, a higher level, in terms questioning the rationale or legitimacy of using discounted cash flow in investor state cases. There are some questions asking if, for example, investment, there is an inherent risk in investment, but discounted cash flow seems to disregard that risk in the investment, while given investors a sort of insurance policy. And sometimes even encourage the investors, especially in emerging countries, the tribunals might give the investor a benefit of doubt because they see investors as pioneers in opening that market. So they would actually encouraging the investors by giving them extra compensation for investing in that market. Does that by itself says the investor state arbitrations or using DCF investor state arbitration is absolutely pro-investor? In that sense, is there any other alternatives that state can use, valuation method state can use, that is pro-state? And some other participants ask, are tribunal members familiar with the intricacies of valuation techniques? So other than DCF, are they familiar with the other type of valuation techniques? It's a practical question. And also in practice, it seems tribunals often prefers to take on expert evaluations presented by one of the parties as a whole, instead of doing self-analysis or second guessing or review their evaluation method. What can parties do to encourage tribunals to review the methods presented by one of the parties? Should parties encourage tribunal to hire independent expert in doing the evaluation? And also participants also ask for any practical recommendations or suggestions on how the state in a case, when facing a case, to make sure a tribunal can consider other alternatives of valuation methods. Should it be done in the treaty, or is it already too late when a case is challenged against them in the tribunal? So I think that's the most of the questions at this point. I'll come back in with the second round if time allows. Thank you.
Thank you very much, Joe. So for sharing these all these questions, very interesting questions, challenging ones also, I think. So I would like to turn now to our panelists. I don't want to dedicate specific question to any of you, but maybe you would like to pick up on some of them. And then I would like to start with Christina to give her a chance to maybe pick up on a few of these questions you would like to react on, as shared by Joe. And I will then turn to other panelists before we go to a second round, if time allows for. Christina,
Sure.
would you like to start?
I'll try to get through as many as I can. There's a lot here, but fortunately, I'll be helped out by my fellow panelists, I'm sure. The first question was a technical one, whether you take into account, subsidies and tax treatment. And the answer is yes. You would apply the tax treatment, for example, that is, as long as it's not the disputed measure itself, but is part of the calculation in the but-for world. Certainly, you take the world in which you find it as of the valuation day. So I think that can be addressed pretty quickly. Another set of questions really went to the tribunal familiarity and engagement with the damages analysis. And certainly, I have found some arbitrators are more keyed into these issues than others. And in fact, that's how some of them get selected, particularly in very complicated, high-value cases. You often find that the investor will try to select a arbitrator who's known for really understanding and getting into the issues of damages. I do agree that sometimes, at least there's a perception that tribunals will either adopt wholly one expert's analysis versus the others. That requires, a high level of understanding to be able to parse out different components that you're willing to accept and not accept. I think a way some tribunals have gotten around this, or at least experts have tried to be sensitive to this particular issue, is by presenting a joint model, or at least one of the experts, typically the investor's expert, will present a model in an Excel file that can be manipulated in the sense of plugging in different parameters. So you can, select a different kind of discount rate. You can select a different duration for the project. You can select a different forecast of prices, for example, and it really allows the tribunal to make its own adjustments to the model, and that, I suppose, to some extent allows it to engage a little bit more in the analysis. Whether tribunals should hire its own expert, I mean, that's I don't think it would be at the expense of the parties having their own experts. I don't think any party will want to relinquish that ability to have its own expert. So if anything, it just becomes even more of a battle of the experts, and it will obviously inflate the costs of the arbitration. But I do see, there may be value potentially in having a damages expert that can really, if used properly, explain complicated issues to tribunal members. I do have some concern that the tribunal's expert becomes a fourth arbitrator and potentially the decision maker. So that certainly, I don't think, what's being contemplated by the parties when starting an arbitration. So I'm happy to end there, because I do want to be respectful to everybody else and being able to share their thoughts on these questions. But I realize there's others I have not been able to address right now.
Thank you very much, Christina. Yes, I think we still have a lot of questions on which maybe Luis and Tony can react also. And I would like to turn to Lou, sorry, and see what he would like to pick up. Personally, I'm wondering if you want also to focus on the question related to investor using, the importance of feasibility studies. I can add financial modeling of project, particularly in mining sector, and how this can be used to manipulate maybe the techniques, etc. If you can also touch base on that at the same time while we are responding to the questions, some questions. Thank you.
Let me also comment on the tribunal itself doing its own analysis, which Christina referred to. I've seen that happen when they get an Excel spreadsheet, as Christina suggests. They can put in their own numbers, and sometimes do, or mixed numbers. You just change one that an expert put in. In the modern DCF, I think it's too complicated for them. Yes, they can buy the model, but what happened in the Tetian case is they clearly didn't like the answer that came out of the modern DCF submitted by the investor, and they just arbitrarily reduced the number. If it had been a traditional DCF, they could have done it through changing assumptions, and it would be quite visible why they did what they did. But in the Tetian case, the reductions were very arbitrary. There's no clear explanation of why they chose the particular reductions they did, except it looks as if they just found the number too high and reduced it. The independent experts, I've seen it only in one case, and I was not testifying in that case, so I know relatively little about the impact, although I do know the expert, and that's the Aguas Argentinas case, where I do think that the expert did help in disentangling some complicated expert testimony. How general the use can be, I don't know. I just haven't experienced it. Sometimes the tribunal puts the experts on both sides to testify at the same time and to argue with each other. I don't know whether it's productive. It's more a skill than oral argument that wins rather than content when it happens. But it is interesting, and I've done it. It was sort of fun, but still, I'm not sure it was very productive. Yes, on the incentives. If investors are given incentives, the assumption by the tribunal is that that affects the market value, and they're built into the valuation. What I've seen happen, what should have happened in the Tetian case, when the modern DCF was used, the investor did not present the results of simulations. The method allows runs of simulations to simulate outcomes, produces a scatter diagram of outcomes, and that was very important and ignored by the investor, and I think not thoroughly understood by the tribunal. 46, if I remember right, 46% of the outcomes were negative, even though the average value was quite high. That's where something like the 6 billion appeared. And one could have argued and should have argued, and did, but tribunal didn't get it, that the median was a better number than the average, because at the tail end of the distribution, there were some very high results that raised the average value considerably. In reality, those high results would never have been allowed. The government would have taxed or found some other way of capturing those extremely high income results. So there's more that can be done with the modern than can be done with the simple DCF, but it takes a good deal of knowledge on the part of a tribunal to understand it.
Thank you very much for your response and your comments. Now I would like to turn to Tony. If you want to pick up on some of the question, I particularly was question related to how it can be done in treaties, in contract, if it's too late, to try to address and provide principle that could guide investment tribunal when they are deciding the appropriate valuation technique.
So I will try to answer that question. I think the starting point is we're talking about the rationale for DCF, and some people are asking, how is it possible that tribunals are now favoring this method? It's somebody said pro-state. I mean, it's obviously not favored because it's perceived to be pro-state. It's favored because it's perceived to be the method that real investors use. So I think tribunals simply feel that they are doing what is economically most rational, so in the face of that, legal authority doesn't really play any role. It used to, but no longer. The Tetian case is a good example because the modern DCF method that was propounded by the claimant. So Pakistan made a forceful argument to say, but there's no authority for this. Never has this been accepted, etc. But the tribunal says, who cares? Who cares about legal authority? What matters is that I, as a tribunal, I'm convinced that this method is accepted in valuation practices in the mining sector, right? That's all that matters. So legal authority is sort of swept aside. Now, in terms of the alternatives that we could think of, I mean, alternatives, they do exist. I think we have been led to believe that there is no other way when there is. So first of all, there is much more use for the comparables method than I think is admitted. So there are cases, for instance, there's a case against Bolivia, the Kiborax case, where a mining concession, again, had been acquired by the investor 2 years before for less than $1 million. So they had bought it on the market for less than $1 million. Then it was valued by the tribunal at, I think it was between 40 and 50 million. Now that makes no sense. So had they used the comparable method properly to check, well, does this make sense? Maybe they would have realized that the DCF method was not sound. Now, again, the book value also has more space than is recognized in cases where the contract has not been obtained, the license has not been obtained. There you cannot say that the investor is entitled to anything other than to get their money back. It's difficult to argue that they have any real entitlement to profits, which is what is assumed in the use of the DCF. And finally, when it comes to calculating profits, I mean, we already have cases that are using a reasonable rate of return to calculate what that proper measure of profitability should be. I think that's really the way forward. In terms of reforming treaties, it's difficult to think of the sort of exact wording that we could use, but certainly the compensation question should be addressed. It isn't addressed now in most treaties. Damages are subject to sort of principles that have been developed through case law and references to customary international law. So there's nothing really in the treaties. There is definitely space for that, and there is space for quite strict rules about preventing tribunals from being too generous in awarding compensation for, especially I think the key issue is awarding compensation for expectations about future profitability. I think that's where sort of the most unreasonable amount of speculation happens, and this is also what lies behind the sort of the inflation of awards that we began with a mention of.
Thank you very much for clarifying that and reiterate the fact that yes, states can act decide to put some principle, to put some guidelines, clear guidelines on tribunal, at least on some specific, quite controversial scenarios, and thank you for that. I would like to remind to the participant that, as pointed earlier, IISD published a paper on that, authored by Jonathan Bonniccia and Sarah Brewin, and my colleague Nyaguti just posted the link on the chat, so please go and have a look on it. And we have a shorter piece which is coming with specific proposal and ideas on options, for just government to consider how they can handle this issue in the investment treaties, at least in treaty-based ISDS procedures. So now we are getting slowly to the end of this session, but I know that we still have a lot of questions and interesting questions. So I would like to give you opportunity to react on. What I would suggest to do now is first to ask Usman if he wants to pick up on one of the questions. And then I will ask Joe to share with us what are the main questions that came up while we are discussing, and for each panelist to pick up one question, one key question he wants to react on before we end with this session. So Usman, maybe you would like to react on something that was said by the panelists, or on a specific question or comment that was raised in the chat.
So glad you allowed me to share a view. So most of you may know that Pakistan is now in the position of either walking away from all the bilateral investment treaties that it was a signatory to, or to renegotiate them. The problem lies much earlier and much beneath the surface. Countries really need to take into account the stage when these treaties are being negotiated. I cannot stress that enough. And I have seen, especially developing countries, I have worked for the British government, I have worked for the American government, I have seen especially in developing countries how easily they are expected to waive off their sovereign immunity and grant these blanket waivers, which is extremely dangerous, because then the fair and equitable clause walks in and completely turns the tables around. So before a country comes to the stage where it has to either cancel its bilateral investment treaties or to renegotiate them, it is essential that they have not overlooked what is seemingly a small aspect without considering its long-term effects. So thank you. Yes.
Thank you very much, Usman. This is really key. We are discussing damages today, but we should keep in mind that before we go to the damage phase, it means that a violation of investment treaties has first been concluded by the tribunal. And this is where negotiating good investment treaties is very important from the beginning. So thank you very much for that. I have seen a few seconds ago, it seems that one of the panelists raised a hand and wanted to say something. I don't know if this person still wants to say something, maybe briefly. Please let me know on the chat if you still want to take the floor. But then now I will turn to Joe. Is there more questions or more comments that we can address very quickly?
Yes, questions kept coming in for sure. Just before addressing the questions, to echo Usman's comment, I just want to reiterate what Natalie wrote in the chat earlier, that governments are the masters of their treaties and can agree to choose any approach method they like. So I think this is very in line with what Usman was saying. And in terms of the questions, we do have a question asking if the panelists think there is a room or it's worthwhile endeavor for countries to develop a internationally or multilaterally applicable method for damages that can make tribunal or force the tribunals to, like sort of international standards for tribunals to apply in investor state cases. That's one question. And secondly, Also, there are several participants asking some similar questions, because right now we're talking about other global challenges such as climate change, and we know these climate change have caused people second thinking the impact on some traditional industries, especially fossil fuel related investment. Is there any space for including those climate change science modeling in the discussions or quantum discussions for those investments? And also there's another question asking, basically again on the valuation methods and the proof of evidence, how to make sure the investors, when they presenting their cash flows, it's not being manipulated, because or the accuracy of future value, how to ensure that in the tribunal proceeding. So yeah, those are a set of questions for now.
Thank you very much, Joe. And I noted that we have also a few questions in French, but the question were included on your summary you provided. So thank you very much for that. Yes, we are supposed, in principle, we have 1 minute left, but I think a participant will allow us to stay a bit more, at least for 5 minutes, just to be able to wrap up and conclude properly this webinar. So I would like to give a chance to each panelist, in, let's say, 1 minute, to pick up one question and his final thought about this topic. And I would really be interested to hear one of you at least reflect on the question related to the climate change issue. I will ask Christina to start.
Sure. So I am not going to take the climate change issue, but I will take the first one that was raised about whether countries should consider adopting some international method or standard for measuring damages. And I understand where that comes from. I'm not sure necessarily that that's practical, because, you know, valuation has to take place in light of the circumstances, in light of the type of investment, the stage of the investment, what evidence is available. For my perspective, I think the quality of the evidence is what's a huge driver of the method that you are using, whether you have an operating project or you have a contemporaneous objective business plan. But I do think there's scope for states to set out criterion in which to guide tribunals in the circumstances in which it may be, for example, appropriate or not appropriate to apply the discounted cash flow method, in the same way that states have tried to introduce elements of, you know, Seleni for the purposes of determining whether there's an investment that exists. I think there's definitely a scope for giving more guidance to tribunals and parties for that matter. I think I'll stop there since we're 1 minute over the half hour.
Thank you very much. I will turn now to Luis and then Tony. And please, yes, very briefly, so we can take advantage of still having the translation for the discussion. Luke, you have the floor.
I think the only way you'll get much standardization on quantum calculations is to have a genuine appeals process in the system, so that you have the equivalent of the Supreme Court setting standards which then have to be followed by other tribunals. I don't think we're very close to that yet, but I think it could be useful. And there are criteria. I mean, look at the US with eminent domain. There are criteria for evaluating takings by the government. You know, and they do allow for differences in different properties that are taken. I think one could get there with an appeals process. I do think new treaties are beginning to take into account legitimate regulatory action, and a lot of it was driven by the Australian tobacco case, and that got international concern. and treaties are beginning to reflect that, but it's a slow process.
Thank you very much, Lou. And then now, Tony, some final remarks.
I will say something about the climate.
Yeah, thank you.
But Usman is right. We should take treaty drafting, treaty reform very seriously. However, I don't want this to make it seem like the current approach is legally unquestionable. I think it's the opposite. I think that as a matter of current law, tribunals are getting it wrong. I think that should be emphasized. Treaty reform is necessary, but to prevent them from continuing to get it wrong. Now, the climate question, I think I'm just going to give an example that I think speaks a lot to what is wrong about the use of DCF. Take the example of reform that makes it much more costly for an oil company to extract oil from the ground, to the point where it is no longer profitable for it to get it out of the ground, right? It could initiate proceedings, investment arbitration proceedings, to claim that it's been the subject of an expropriation or something like that, which it could very well succeed in doing, right? If that is the case, compensation would probably almost certainly be calculated on the basis of DCF. And through that means, it would obtain as compensation the value of the oil fields that it would no longer have been able to extract because of the climate change legislation. If this doesn't show how profoundly flawed is the current approach to DCF, I don't know what does.
Thank you very much for this really, yes, final remarks that, I mean, everyone should keep in mind regarding this topic and the DCF methods. Now we are we really need to close the session. I apologize for those who asked a question or wanted to take the floor and we won't be able to have more time for discussion. But anyway, we remain at your disposal if you want to ask questions, follow-up questions. You have our contacts. You can always reach IISD regarding that. So I would like now to thank all the participants for their insightful questions. I will just make some final remarks on behalf of IISD and to really extend my sincere thanks to Usman, Christina, Tony, and Lou for making the valuable time available across a wide range of time zones to join us for this enriching discussion. And particular thanks to Usman for sharing his Friday evening with us from Pakistan. And we greatly appreciate all of you sharing your insight and knowledge with us. I think after this webinar, we all have more and a better understanding of what is DCF, what are the issues, the main challenges, and what countries can try to explore as solution. Thank you also to the interpreter that accepted to stay a bit longer than expected, and to Sophia, my colleague, for her technical moderation and communication support, and to the rest of the IISD team behind this webinar, particularly Joe Nyaguti and Sarah Brewin and Jonathan Bonitsha that really designed this webinar. As mentioned in her opening remarks, IISD plans to continue the discussion around the key issue of compensation under investment treaties this year with a series of webinars dedicated to the topic. So please keep an eye out for the next in the series. And thank you everyone for joining us, and enjoy the rest of your day. Thank you very much, and bye-bye.